Analysis of the Karen Read case. 1. Executive summary. The case of Karen Read is a center of intense public and legal focus after the death of Boston police officer John O'Keefe in January 2022. Read, O'Keefe's girlfriend, faces charges of second-degree murder, manslaughter while operating a motor vehicle under the influence of alcohol, and leaving the scene after causing personal injury or death. The prosecution argues that Read intentionally struck O'Keefe with her SUV and left him to perish in the elements. In opposition, the defense claims Read is being falsely implicated in a cover-up, suggesting O'Keefe was killed by others after entering a private residence. The first trial in this highly publicized case ended in a mistrial, showing the difficulties and divisions surrounding the proof and testimonies offered. Disputes concerning the investigation, particularly the actions of the lead investigator, have added to the case's public attention. The widespread media coverage and the strong opinions held by the public highlight the need for a comprehensive and objective review of the facts and arguments put forth by both the prosecution and the defense. The inability of the first jury to reach a unanimous decision highlights the intricate nature of the case and the different readings of the available information, requiring a detailed examination of these differing viewpoints. 2. Background of the case. The events leading to John O'Keefe's death occurred on the night of January 28 to 29, 2022. Karen Read and John O'Keefe spent the evening socializing at two places in Canton, Massachusetts, C.F. McCarthy's and the Waterfall Bar and Grill. They were part of a group that included Brian Albert, another officer in the Boston Police Department. Later that evening, the group went to an after-party at Albert's house at 34 Fairview Road. The next morning, January 29, 2022, O'Keefe was found unresponsive in the snow outside Albert's home. Karen Read was present at the location when he was found. Afterward, Karen Read was charged with second-degree murder, manslaughter operating a motor vehicle under the influence of alcohol, and leaving the scene after causing personal injury or death. Read has entered a plea of not guilty to all these charges. The sequence of events from the night of January 28th into the morning of January 29th, and the participation of multiple individuals, create an involved story that needs close review to grasp the different accounts of what happened. 3. The prosecution's narrative. The prosecution's main argument is that Karen Read intentionally struck John O'Keefe with her SUV and then left him outside in the snowy conditions, leading to his death. They have presented several pieces of proof to support this claim. Witnesses supposedly heard Read make statements at the scene, such as "I hit him" or "could I have hit him?" In addition, red plastic fragments, supposedly matching the broken tail light of Read's vehicle, were found where O'Keefe's body was located. DNA proof recovered from a broken tail light has been presented by the prosecution as connecting Read to O'Keefe's death. Testimony has been offered about the couple's relationship, depicting it as troubled, with instances of arguments and strained communications. Read's blood alcohol content at the time has been a point of argument, indicating she was intoxicated. The prosecution's case seems based on a combination of these elements: alleged admissions by the defendant, physical proof linking her vehicle to the scene, and details pointing to a possible motive. The focus on the difficulties in the relationship might be an effort to establish a reason Read might have acted violently toward O'Keefe. 4. The defense's narrative. The defense asserts that Karen Read is innocent and is being framed as part of a detailed cover-up. Their main point is that John O'Keefe was likely killed inside Brian Albert's home, and Read had no part in his death. The defense suggests O'Keefe did enter the house after Read dropped him off, and inside he was attacked perhaps by Brian Albert's dog or by one of Albert's relatives. To back this account, the defense has raised several points. They claim the injuries found on O'Keefe's body do not match being struck by a vehicle and are more suggestive of a physical assault. They have challenged the reliability of the investigation conducted by law enforcement, mentioning worries about the handling of the crime scene and the collection of proof. Claims that evidence was planted, particularly the tail light fragments, have been made by the defense. The behavior of individuals inside the home has been examined closely, especially Jennifer McCabe's internet search history, which included the search term "how long to die in cold," at an early morning hour. In addition, the defense has pointed out that the lead investigator, Michael Proctor, had personal connections to individuals involved in the case, pointing to a potential bias in the investigation. The defense is building a detailed story that involves alternative explanations for O'Keefe's death and points to others, indicating a coordinated effort to wrongly accuse Karen Read. The detail that Brian Albert's dog was rehomed soon after the incident is something the defense could use to back their theory that an animal attack might have added to O'Keefe's injuries. 5. Key evidence and controversies. Several pieces of proof and surrounding disputes are important to the Karen Read case. Karen Read's SUV taillight is a major area of disagreement. The prosecution claims it was damaged when Read struck O'Keefe. The defense argues the damage happened when Read was backing out of O'Keefe's driveway, or that the proof was altered. Concerns exist about the finding of the taillight fragments, including their location and when they were found. Claims exist that police damaged the taillight more during their investigation. John O'Keefe's body condition is another key feature. The prosecution lists the cause of death as blunt force trauma and hypothermia. The defense claims the injuries are more suggestive of a beating and not matching well with a vehicle collision. In addition, marks resembling dog bites were said to be seen on O'Keefe's arm. Forensic findings have been examined closely. DNA proof is said to link O'Keefe to the broken tail light of Read's SUV. But a forensic scientist testified about finding hair and glass fragments on Read's SUV after it was already in police custody, creating worries about possible evidence interference. Significantly, blood testing of Read's SUV yielded negative results. The investigation itself has been affected by major disputes. The main investigator, Massachusetts State Trooper Michael Proctor, was eventually fired from his position for wrongdoing connected to the investigation. Claims of prejudice against Read, like the presence of offensive text messages he sent, have appeared. Proctor was charged with giving out private information about the case. These issues resulted in an internal affairs investigation. Even though he was fired, Proctor's name appears on both the prosecution and defense witness list for the next trial. The defense has even accused Proctor and others of changing evidence to frame Karen Read. Adding more dispute are claims of evidence tampering. The defense asserts that surveillance video of Read's SUV at the Canton Police Department was changed or intentionally kept back by the prosecution. Worries exist about the ways evidence was gathered at the crime scene. The defense has particularly challenged the reliability of the tail light proof, indicating it might have been placed. The legal proceedings have seen discovery problems. The defense has accused the prosecution many times of keeping back important proof, like video recordings and associated metadata. Arguments appeared about the release of details about the defense's expert witnesses. Judge Beverly Cannon herself stated grave concern about new information provided by the prosecution concerning these expert witnesses. The disputes surrounding the lead investigator's actions and the accusations of evidence mishandling might greatly weaken the jury's trust in the prosecution's case and the general reliability of the investigation. The many arguments over the disclosure of proof show a very confrontational court fight, where each side believes the other side is hiding or twisting details, possibly influencing the acceptance of main proof in the second trial. 6. Legal proceedings and outcomes of the first trial. The first trial in the Karen Read case started in April 2024 and lasted until July 2024. The first part involved selecting a jury. After this, both the prosecution and the defense showed their proof and had many witnesses testify. A significant point during the trial was the testimony of Michael Proctor, the main investigator, which involved reading text messages he had sent. The defense's plan depended greatly on showing a defense blaming someone else, claiming that Brian Albert and Brian Higgins were to blame for O'Keefe's death. During the trial, different requests were debated and decisions were given by the court, including those about accepting proof and the testimony of expert witnesses. In the end, on July 1st, 2024, the trial finished with a statement of a mistrial. This result happened because the jury was not able to agree on a decision following days of discussion, showing a large split among the jurors. After the mistrial, The defense stated that some jurors showed they agreed on finding Karen Read not guilty of the charges for second-degree murder and leaving the scene of a deadly accident. One juror supposedly confirmed a vote to acquit on the murder charge, but said the jury could not agree on the smaller charge of manslaughter. Judge Beverly Cannon did not poll the jury on this matter or record a partial verdict. That the first trial finished without a guilty verdict points to the state's proof not fully persuading all members of the jury of Read's guilt beyond a reasonable doubt. This result probably shows possible weaknesses in the prosecution's case that the defense will plan to use more in the next trial. The defense's claim of being found partly not guilty brings up complex legal issues about double jeopardy, possibly offering reasons for later appeals or arguments against the correctness of a second trial on those specific charges. 7. Developments leading to the second trial. After the mistrial, the legal proceedings in the Karen Read case have gone on with different appeals and requests filed by the defense. These contain points founded on double jeopardy, claiming that Read cannot face trial again for charges where the jury supposedly decided she was not guilty. The defense tried, without success, to convince the Supreme Judicial Court to remove 2 charges against Read. A federal appeal about the double jeopardy argument was rejected. In addition, the defense requested dismissal of the entire case, mentioning claimed wrongdoing by the prosecution and many failures to share evidence. They asked for leave to speak with the jurors from the first trial. The state, getting ready for the second trial, has centered on making their case stronger and dealing with possible weak spots that might have led to the hung jury in the first trial. Their work has involved trying to keep out the defense's expert witnesses, mentioning problems connected to discovery and sharing. The prosecution tried to get communications between Read and her attorney, claiming that attorney-client privilege was given up. Judge Beverly Cannon has issued some important decisions in the period before the second trial. She rejected the defense request to dismiss the case and their wish to remove 2 of the charges. She decided against the state's effort to get communications between Read and her attorney. The judge allowed the defense to show a defense blaming someone else, naming Brian Albert and Brian Higgins, but removed Colin Albert as a possible suspect. Judge Cannon stated worries about the actions of the defense lawyers in connection with expert witnesses. She directed a larger restricted area around the courthouse for the second trial, trying to lessen possible effects on the jury. Choosing the jury for the second trial started in April 2025. Early movement has been limited, with a small count of jurors chosen on the first day. A big group of possible jurors, counted in the hundreds, has been called. A large part of the possible jurors have shown knowledge of the case, requiring close checking to find any possible leanings. Victoria George, an alternate juror from the first trial, has become a lawyer for the defense. It is expected that the jury choice period might last several weeks. The many pretrial requests, appeals, and rulings highlight the serious issues at play and the confrontational style of the legal proceedings. Both the prosecution and the defense are working hard to form the story and the proof that are shown during the second trial. Judge Cannon's rulings on these different points offer useful views on her view from the bench and might show the probable direction of the next trial. 8. Analysis of media perspectives. The Karen Read case has been covered widely by many news sources, showing the large public attention it has generated. Different news sources have taken different viewpoints in their coverage. Certain sources have centered mainly on the prosecution's narrative, showing the proof offered against Karen Read, like the claimed remarks and the taillight fragments. In opposition, different news sources have stressed the defense's claims of a cover-up and the disputes about the investigation, like the actions of the main investigator and the claims of evidence interference. The participation of Aidan Kearney, called Turtle Boy, a writer who has loudly backed Karen Read and spread the defense ideas, has added a different element to the news story about the case. Court TV has offered live showings and detailed reviews of the legal proceedings, giving watchers direct entry to the court actions. The wide variety of news reports, from standard news stations to separate web sources, points to public knowledge of the case being probably broken up, possibly affected by the particular viewpoints and possible leanings presented by different sources. 9. Background of key individuals. John O'Keefe, a long-serving officer of the Boston Police Department. When he died, he was in a relationship with Karen Read. His family has filed a wrongful death lawsuit against Read and two bars, claiming carelessness. Karen Read, an equity analyst and professor. She is the defendant in the case, charged with killing her boyfriend, John O'Keefe. Read has stated her innocence in public and asserts she is being set up. She has past health problems, including Crohn's disease, a brain tumor, and multiple sclerosis. Brian Albert, a Boston police officer who owned the house at 34 Fairview Road in Canton, where John O'Keefe's body was found. The defense has claimed that Albert or his family members were part of O'Keefe's death. Albert gave testimony in the first trial, saying that O'Keefe and Read did not go into his house the night it happened. He afterward acknowledged meeting Karen Read before O'Keefe died, going against previous remarks made to investigators. Brian Higgins, an agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, who was based at the Canton Police Department. He was part of the group at the Waterfall Bar on the night of January 28th. Higgins had a short romantic meeting and sent texts back and forth with Karen Read in the weeks before O'Keefe died. The defense has claimed he was involved in a possible cover-up. He gave testimony about phone calls made with Brian Albert on the morning O'Keefe's body was located, first saying he was asleep at the time. Michael Proctor, the main investigator in the Karen Read case and a Massachusetts state trooper. He was later fired for wrongdoing connected to the investigation, like sending insulting texts and giving out private details. Even though he was fired, he is named as a possible witness for both the prosecution and the defense in the second trial. Jennifer McCabe, Brian Albert's sister-in-law, who was in the group hanging out on the night of January 28th. She helped Karen Read look for John O'Keefe on the morning his body was found. Her internet search term, "How long to die in cold," made at 2:27 a.m., has turned into a major area of argument in the case. The defense has claimed she might have erased this search and different messages from her phone. Judge Beverly Cannon, the judge overseeing both the first and second trials in the Karen Read case. She has issued many decisions on requests related to accepting proof and court methods. Judge Cannon has stated worries about the actions of both the defense and the prosecution during the court process. Knowing the connections and possible leanings of these key individuals is needed for a full review of the different narratives and for judging the believability of the statements and proof shown in the Karen Read case. 10. Official statements. Law enforcement officials have spoken about the finding of John O'Keefe's body and the later charges brought against Karen Read. The Massachusetts State Police put out a notice declaring the internal investigation and final firing of Trooper Michael Proctor because of his actions during the investigation. The Norfolk County District Attorney's Office has put out notices about the case and the court process. Lawyers for each side have shown their points at length in court. State lawyers have pushed for the acceptance of proof, questioned the defense's expert witnesses, and charged the defense with wrongdoing. Defense lawyers replied by claiming a cover-up by police, wrongdoing by the prosecution, and the keeping back of important proof. Lawyers for other people involved, like Michael Proctor, have spoken. The people directly part of the case have given accounts. Karen Read has always claimed she is not guilty and asserted she is being set up. John O'Keefe's family has stated openly their view in Read's guilt and their resolve to find justice for their son. Michael Proctor's family has supported his deeds and reputation in public statements. Brian Albert and Brian Higgins gave testimony in the first trial, giving their versions of what happened. Looking at these official remarks from law enforcement, lawyers, and the people involved offers useful views on their different stances, the points they are presenting, and any possible leanings that might be present, helping build a more complete picture of the Karen Read case. 11. Case summary. The Karen Read case is still a complicated and fiercely disputed court fight, showing opposing stories and detailed proof. Central to it is the basic argument over the events of January 29, 2022, with the state claiming Read purposely caused John O'Keefe's death and the defense stating she is not guilty against what they call a cover-up. Read is charged with serious offenses, including second-degree murder, while her defense lawyers keep claiming she is wrongly accused. The mistrial in the first trial highlights the difficulties in getting a final decision using the proof shown. The many disputes about the investigation, especially the actions of the main investigator and the claims of evidence interference, make the case more involved. With the second trial moving forward, the result will probably depend on the jury's reading of the proof that often clashes and the strength of the points shown by the state and the defense. The large public and court attention in this case is predicted to go on as the second trial proceeds. The final decision rests on if the prosecution can persuade a new jury of Reed's guilt beyond a reasonable doubt, or if the defense can manage to create doubt about the prosecution's case and back their assertions of a cover-up.